So today we will be discussing about divorce by mutual consent under and according to the Hindu Marriage Act 1955. Section 13B of the Act lays down the rules and process with respect to divorce by mutual consent. Mutual consent divorce was brought by the India Parliament wide amendment in the year 1976 in the Hindu Marriage Act, and it has brought relief to many married couples to have a peaceful separation. Under Section 13B of the Hindu Marriage Act 1955, the parties can seek divorce by mutual consent by filing a petition before the court. So, who can file a petition for mutual divorce? A petition for mutual divorce is to be filed by both the parties to the marriage together. So, only when both parties agree to disagreeing the continuance of their marriage, they together can file a petition for mutual divorce. Only one party to a marriage cannot claim to get divorced by mutual consent. If only one party is aggrieved in a marriage, then he or she has to file a petition under Section 13 of the Hindu Marriage Act under various grounds which had been discussed in the earlier discussion. Now, where can a petition for mutual divorce be filed? Now, once the parties agree to end their marriage, they need to file a petition in this regard. But where do they file the petition? So, a petition for dissolution of marriage by a decree of divorce may be presented to the district court or in the family court of the city or district where the marriage had taken place, or where the husband and wife last resided together, or where the wife is residing at the time of filing of the petition. Next comes, what are the conditions requisite for filing a petition for divorce by mutual consent? There are three primary conditions. Firstly, that the parties to the marriage have been living separately for a period of 1 year or more. Secondly, that the parties have not been able to live together. And thirdly or lastly, that both of them mutually agree that the marriage should be dissolved. Next after this comes the procedure after filing of petition. So once the petition for divorce by mutual consent is filed, the presence of the parties are required in the court for recording of the statement. In the event one of the party is unable to come, such party can appear through power of attorney. Such power of attorney preferably should be a family member of the spouse. Once the statement is recorded, it is commonly called first motion has been granted. After the first motion is granted comes the cooling period. That is, parties are called upon to wait for 6 months period before moving petition for second motion. This period is extendable unto 18 months. This 6 months period in mutual consent divorce is generally called cooling off period. This 6 months period are given to parties to think about their relationship again. So it is basically given for a reconciliation if possible. Now what is the procedure after the cooling period? So after 6 months period has elapsed, if the parties have been unable to resolve their differences, they will have to appear in the court again for making a second motion, confirming the mutual consent filed earlier. So here also, statement of parties would be recorded again. During the period of 6 months, that is, before moving of this second motion, both parties have liberty to withdraw their consent for divorce. It is only after this second motion that the court passes an order dissolving the marriage by granting decree of divorce, and thereby the marriage stands dissolved. So once again, if you have missed this part, what is the duration for filing of this second motion? So the second motion petition may be filed at any time between 6 months and 18 months, 18 months from the date of the filing of the mutual consent divorce petition. If the second motion is not filed within the stipulated period, then the divorce petition gets automatically cancelled and the parties have to freshly apply for a divorce by mutual consent again. Now comes this waiving of cooling period. This is not a statutory part but has come by a precedent. The cooling period can be a real frustrating thing for the parties intending to dissolve their marriage by mutual consent, since they have to wait for 6 months at least after filing a petition for mutual divorce. But in a 2016 judgment in a matter between Nikhil Kumar and Rupali Kumar, the Supreme Court, keeping in mind the peculiarity of the case and the difficulty in abiding to the statutory cooling period, announced the statutory period of 6 months is waived and the marriage between the parties is dissolved. So, if valid and just grounds can be brought before the court, there is a probability that the cooling period may get waived or shortened, provided it is subject to discretion of the court always. So, this is all about divorce by mutual consent. Hope you find it useful as well as helpful whenever you talk about this topic the next time with anyone. We will be discussing about another interesting legal topic in the coming week. Till then, thanks for watching.